Does the Supreme Court's decision on Obamacare really make it constitutional? And more importantly, how does the nation move forward toward repealing Obamacare? For answers, Liberty News Network asked attorney Joe Wolverton, a former college professor and legal correspondent for the New American Magazine. For Liberty News Network, I'm Tom Eddlem. The Supreme Court said Obamacare's individual mandate cannot be constitutionally justified using the Commerce Clause, but can be justified under the Taxing Clause. What does that mean?
That basically means that Chief Justice Roberts has decided unilaterally to rewrite Obamacare because those who wrote the act that purports to be a law and those who defended, including the president himself, adamantly denied from the beginning that it's a tax and that it is an exercise of the Commerce Clause. So Chief Justice Roberts has taken it upon himself to rewrite the law, taking away what was called Obamacare and making it now Roberts Care, which determined that the individual mandate and the requirement, that is to say the requirement that every American purchase a qualifying health insurance program or face a tax penalty is now not a penalty, but it is a tax. And while Congress can't regulate activity, they can tax non-activity. So that's what it is. It's now a tax on non-activity and not a regulation on activity, which the Chief Justice said would be unconstitutional.
Okay, so one of the points you made is that it would be a direct tax. And one of the things that I found from Justice Roberts' decision was he describes a direct tax this way. He says, quote, "A capitation, after all, is a tax that everyone must simply pay for existing, and capitations are expressly contemplated by the Constitution." But isn't the fine for Obamacare just a tax for simply existing?
That is true. That is exactly right. The tax, for simply existing, assuming you don't obey the mandate, that is to say you don't purchase the health insurance policy. But this tax, as he calls it, which it isn't a tax, but by determining that it is, by declaring that it is a tax, he has essentially forced himself into the corner of defending it as a direct tax, which, of course, according to the Constitution, has certain requirements that must be met for a direct tax to be imposed, and none of these requirements are met by Obamacare because, as I said, from the beginning, none of the authors or advocates intended it to be viewed as a tax. So they really never put in anything that would help the court or anyone else interpret it as a tax. So Chief Justice Roberts has painted himself into a bit of a legal and constitutional corner because he'll have to say that it's a tax, he'll have to say that it's a direct tax, and by doing that, he'll have to define a direct tax as something that it has never been defined as before.
My understanding is that the Constitution says that a direct tax has to be apportioned according to representation. So they would all have 50 different rates in a direct tax, and that's not the case in this tax.
That's not the case. And that, and there's something to be remembered, Tom, is that what is the purpose of a tax? The purpose of a tax is to raise revenue, correct? Well, if everyone obeyed the individual mandate, no revenue would be raised. Therefore, it is not a tax. It's a tax that isn't a tax. And the reason it's not a tax is because of the penalty. So by declaring it a tax, Justice Roberts has said that, it's a revenue-raising law. Well, if everyone obeys the law, no revenue will be raised. How is it a tax? Well, it isn't. It's a penalty that has now been rewritten as a tax, and it's a shocking example of judicial activism and the accumulating of powers. It's amazing.
Okay, you suggested a remedy in your article, Supreme Court Rewrites Obamacare, at thenewamerican.com. Would you tell us what that is?
Well, my take on the remedy is that, and it's the remedy that I believe is the simplest and the soundest, constitutionally speaking, and that is nullification. That is to say, the states, through the exercise of the 10th Amendment and, of course, their natural right to rule within their sovereign borders, would pass a law stating that the mandates of Obamacare are null and void within that state's borders, and then going the next step in criminalizing any state agent who participates in administering or executing the unconstitutional aspects of Obamacare. I mean, we know that James Madison and Thomas Jefferson were big supporters of nullification in this sense, and that it is a constitutionally sound method of checking the federal government. We have to remember that The states created the federal government and not vice versa. The states can give and the states can take away. And in this sense, the states gave very limited power to the federal government, and that power did not include the power to force Americans to purchase health insurance or any other commodity or good for that matter. And that it is up to the states now to repair those fences that it once built around federal power. It's up to them, and nullification, I believe, is the best way to do it. Simply for the states to say, we didn't give you this power, therefore you don't have this power, and what you say violating this power has no force of law. As Alexander Hamilton wrote, it is null, void, and of no legal effect.
And of course, you mentioned Jefferson and Madison. Jefferson was the one who coined the term nullification when Jefferson wrote the Kentucky Resolutions, which nullified the Alien and Sedition Acts back in 1798. Would you just sum up the constitutional question that at least 4 justices agreed to, which is that the individual mandate can be upheld upon the Commerce Clause? Would you say a few words about that, or whether or not that's accurate?
Well, it is not accurate. That was the first shell of what I describe as the Obamacare shell game. The little ball of individual mandate, we expected it to be found under the Commerce Clause shell. That is to say, the justices would uphold or not uphold the individual mandate of Obamacare, saying that it is a rightful expression of the Congress's power to regulate interstate commerce. Basically, what they would be saying by holding that as constitutional is saying that Congress can regulate interstate commerce. Well, we all agree with that. If a person doesn't have a good health insurance policy, he'll be unhealthy. If he's unhealthy, he's not going to be able to contribute to commerce. And if he can't contribute to commerce, that affects all commerce, and that will affect commerce between the states. And no one's going to argue that Congress can't regulate commerce between the states. Therefore, by the transitive properties of these justices, they believe that if you don't get a health care policy, you'll get sick. If you get sick, you're not going to contribute to commerce. If you don't contribute to commerce, commerce is affected, and since commerce is affected, Congress can regulate it. There we go.
Well, that's quite a stretch. I mean, it's almost what Justice Ginsburg argued in her dissent, that by the act of breathing, we allow commerce to continue, or by the act of eating the correct kinds of food, we allow commerce to continue, and that is within the purview of Congress to regulate.
Well, she firmly believes that, as do most people of her political ilk. They believe that the Commerce Clause authorizes the Congress to regulate nearly every activity. When they say regulate, that's just a key word. What they really mean is Congress can punish every activity, or Congress can require any activity. The question I have is, what will happen if Congress decides 10 years from now that by some miracle people with good sense get elected to Congress and decide that, for example, unconstitutional though it may be, they may decide that every American needs to own a weapon. What will the liberals say then? What will the justices on the court say then? Will that be constitutional? Because it's mandating some sort of behavior, and like they did in Lopez, the Lopez decision, basically saying that having a gun might scare someone. If you scare someone, they can't do well in school. If they don't do well in school, they won't get a good job, and if they won't get a good job, it'll affect commerce, and since it'll affect commerce, Congress can regulate it. Therefore, don't have a gun within half a mile of a school.
Right. Of course, there are very few places that aren't within a half a mile of a school.
There you go.
I read your article online on the New American about Mitt Romney and his reaction to it. He says, and he had a big poster in front of him saying, "Repeal and replace Obamacare," and I wonder, replace with what? It sounded like he was going to replace it with exactly the same thing.
Well, 2 points, Tom. Number one, Obamacare was already repealed and replaced by Chief Justice Roberts. He repealed Obamacare as written and replaced it with something new, declaring the individual mandate to be a tax, which is not what it was. So I guess Mitt Romney's happy because Chief Justice Roberts did repeal and replace Obamacare. But in response to the question regarding Mitt Romney, what he said was as unconstitutional as anything Chief Justice Roberts wrote by saying that on his first day he will repeal Obamacare. What constitutional authority does he have to repeal anything? None of us should be surprised. He's no friend of the Constitution. He has just a week and a half ago, declared that if he decided to go to war with Iran, he wouldn't need Congress's approval. That's not the sort of man that cares about the separation of power or enumerated power or the Constitution at all. He is a man who seeks power, and once he has it, he will use it to do as he sees fit, just as we have seen for 100 years now.
For Liberty News Network, I'm Tom Eddlem reporting.